Okay, from the beginning. All right, let me see. Oh shoot, I lost my page. So this is, Jessamine, this is a part of the DC Legislative Update class, which is a course for credit that I teach with GCAR. We're not going to do the whole course. We're just going to do the section about rentals today.
Cool.
Let me see here, and we are going to start. Mel, here comes Mel. All right. And okay. Let's wait to see what we get here with Mel. Hey, Mel, how are you?
Hi there, Dan. How are you?
Doing fantastic. And Irene is coming too. Good deal. We got all the ladies today. All the ladies. Mel, do you know Julie and Jessamine and Irene?
I know Irene.
Hi, Irene.
I know Irene too. Hi, Irene. Oh, she's muted.
Hey,
There she is. Hi, Irene.
I have a question.
Yes.
Where is this meeting?
Where is what?
Where is this meeting? I'm at the office, like a joke.
It was supposed to be, it was not going to be in the office. It's going to just
Oh, Irene.
just
Oh man.
Irene
Okay.
finally shows up to one.
I did because it's actually at 2 p.m. and it's actually a time and I wanted to record it. And now I'm an idiot. But hang on, let me cancel a 3 o'clock that I scheduled across the street because I don't want to wait here for an hour.
Okay.
When I can be closer to home.
Okay. All right. All right. Shafiq is here.
Hi, Shafiq.
He's not connected yet. He's connecting.
Okay.
He's all right. Once he joins, we'll get started here. All right. So, like I said, this is part of the DC Legislative Update class that I teach at GCAR. This is probably going to be 1/3 of the course. And so let's start out with making sure that you all know how to find the Office of the Tenant Advocate, which is going to be a very important resource for you and a tool that you really need to get familiar with and have your landlord clients familiar with it, as well as your tenant clients familiar with it. The link is here in the gray up above the white page. So just get yourself familiar with that office and make sure that you know what we're talking about when we're talking about the Office of the Tenant Advocate. So they are kind of the clearinghouse of resources for complaints and for understanding what the tenant's rights are in the district. If you've got questions, just stop me and we'll address those questions and kind of dive into those. All right, so let me minimize my screen here. Okay, so the website of the Office of the Tenant Advocate is your asset. It's not your liability. Sometimes we end up feeling like they are our enemy as listing agents and as landlords, but they're really not. They can be a very useful advocate to help you to keep your clients out of trouble. This website has robust information, resources with everything related to tenancy. Get in the habit of using it and learning its contents because it's packed full of useful information and tutorials. All right, so jumping into the law and DC tenant laws, that's Title 42, Chapter 32 in the DC Code, and that link is above. So whenever you see a page here referencing laws, it's going to be in the link at the top of the page. So this is basically what we're talking about. So Chapter 32 covers all things related to landlord and tenants. So the big things that you need to start being concerned about in DC as of last year, April of last year, the laws became effective. So the reference March 1st, the laws were enacted by the city council, signed into law by the mayor, and it became effective as of April. And so as April is as of last year. So the first issue is the topic of tenant screening. So before you can screen any tenants or ask any tenants any questions at all about how qualified you are. So you get a phone call on your listing and you get, or and a prospective tenant says, hey, I'm interested in 123 Main Street. And and in the past, what we've done is we've gone through the habit of trying to pre-qualify them. Well, this new law tells us that we cannot do that, because before requesting any information or fees from the prospective tenant as a part of tenant screening, a housing provider shall first notify the prospective tenant in writing or by posting in a manner accessible to the prospective tenant the following information. So the amount and the purpose of each fee that is going to be requested from them, whether that's mandatory or voluntary, that may be charged to a tenant or prospective tenant, and whether the fee is deposit is refundable. So when you're talking about the application fee, you cannot begin to qualify that tenant until you've given them the information that's discussed here. So, you know, so you need to be able to provide the information to them in writing. The amount of the fees or deposits and whether those are refundable or not. So generally speaking, we usually say that the deposits are not refundable. That's a fee that's applied, and we must state that in writing to the tenant before.
The application fees are not refundable.
That's what I'm talking about.
Yeah, okay,
That's what I'm talking about. Yeah.
okay, good.
Yeah. The types of information that will be accessed to conduct a tenant screening. So what are you going to be asking in your, what's going to be accessed in order to qualify those tenants? So we need to go into detail about that, and we'll talk about that here in a minute. And then the specific criteria that will be used as a result of automatic denial. So what kinds of criteria is an automatic disqualifier from that your landlord has told you, your owner of the property has told you that they want to automatically disqualify somebody from? You need to specify what that is.
Like if you have a credit limit on it, or
Well, it could be something like, you know, they have 2 or 3 late pays, right? If they've got collections, if they've got, you know, things that are in play, you know, that are causing, you know, that your landlord doesn't want to deal with. If they've got any amount of, you know, if your landlord is saying, all right, if you've got any collections other than medical collections, because we can't discriminate against medical collections. So if your landlord is saying, I don't want to deal with anybody who's got anything in collections, okay, then that's the standard that you would be disclosing up front to them. There are many other examples of that. We'll get more deeply involved into that. So any other additional information that may cause a denial. Now you have to be careful about what you're going to state is allowed to cause a denial. So prior to requesting the information or fees, you have to state to the tenant, if a credit or consumer report is used, the name and the contact information of the credit consumer reporting agency. So if you're using RentSpree, and as a matter of company policy, RE/MAX Distinctive only allows us to use RentSpree to vet our tenants. We do not allow the use of any paper applications. As a matter of our company policy, we only allow the use of services like RentSpree or other similar services that are online, and where there's a secure portal that information can be transmitted and uploaded to you. Any questions on that so far? RentSpree and similar ones. So we got to name the consumer credit reporting agency. If you're using RentSpree uses TransUnion. So you would have to state that we're using RentSpree. Here's the link to the RentSpree application file, to the application for this property. And RentSpree uses TransUnion. So your credit report as it's stated in TransUnion is what we're going to be pulling.
Did the RentSpree have a responsibility to also explain who they're using and how they're doing this? Or
they do, and they disclose it.
Yeah,
It is-
that's what I thought. So I thought it was kind of a little redundant with both of us, but okay.
Well, it's the law. So this is strictly talking about the law as it applies to you as a listing agent or you as an owner. So, all right. The next thing that it requires us is a statement of when the application will be approved or denied. So if you're taking applications today on, what is today, May 7th, and you're going to say that the applications will be approved by May 10th or May 15th or whatever, you have to give them that date up front. Before you start qualifying them and to asking them any kind of questions about how qualified they are, you have to disclose to them all of this information. The next topic is a statement in writing of the applicant's right to dispute. So you have to tell the tenant in writing that they have a right to dispute a rejection if they receive a rejection on this as of this application. So the law is not clear about what happens when a tenant does dispute the rejection, and whether or not that ties you up for a prospective different tenant that is later to apply. So for now, we're operating on the assumption that there is no obstruction of you continuing to market the property and obtain a successful tenant. Just be aware that there is the possibility that there could be a dispute that is held by the Office of the Tenant Advocate, and that dispute could be adjudicated by that office, and then later you would receive some kind of disposition of what that means for the prospective tenant who feels that they were rejected unfairly.
I'm sorry, I don't know how to turn my camera on, so I don't know how to raise my hand, so I keep it.
Okay, yeah, just
Is that
voice
okay?
it. Yeah, just
Okay,
voice it.
is there a special way that they handle their dispute? I mean, do we tell them if they say, yes, I want to dispute this, and we say, okay, do this? I mean, what do
Yeah.
we tell them?
Yeah, so they would have to contact their office and dispute it through their office. Now they can also dispute it with you, and to say, I believe they can tell you that the decision was based unfairly, and then usually what will happen there is you'll have to refer it back to the office.
When you say the office, what office?
The Office of the Tenant Advocate.
Oh, that office. Oh, so
Yeah.
they dispute it through that office?
Yes.
Not just, okay, that's where we send them. If they want to dispute, we say, get in touch with the DC office
Yeah.
of Landlord Tenant Affairs or whatever it is?
Yep. Yes.
Okay, all right.
So you've got to provide a statement in writing of the applicant's right to a refund of any unused application fee. So right now, as of January, until January 1st of this past year, the maximum fee was $50 that you could charge to a tenant for a screening for a credit check screening. And so you were not allowed to charge any greater than $50. Now as of January 1st of this year, there's a new formula, and we'll talk about that in a minute. But right now, the next topic is that the applicant may file a complaint with the Office of Human Rights or pursue civil action in court. So those are some opportunities that we must disclose to the tenants, to inform the tenants that they have the right to file a complaint if they feel that they've been unjustly denied. Now, this is probably going to cause you some stomach ache if you're really thinking about this, because now you're telling them, yes, you have a right to file a complaint against me or my landlord because we rendered a decision against you. And how many people are likely going to utilize that as an opportunity to file some kind of discriminatory complaint against you? Hopefully not a lot, but there is a possibility there. So you really need to be very, very careful about who and how you decline in the rental process. All right, the
quick question on the practicalities of that. So in the scenario, you have two applications. One has, I don't know, whatever, a 500 credit score, and your landlord said anything under 600 is out. And you pick somebody else, 750 credit, whatever. If somebody informs you they want to make a dispute, is it just to file a complaint against you and the landlord, or can you still proceed with the person you accepted? Is that correct?
The law is unclear, is silent about that. Okay. Now, part of what you said, we're going to cover something in a few minutes here about what you just said about using the credit score. And one of the things we're going to discover is that you cannot use a credit score as the reason to deny somebody for their application. You can use the contents in the credit report, but you can't use the credit score as the primary reason. And as a matter of company policy, we are asserting as a company policy that we should not even be using the discussion of the credit score at all in our presentations to our landlords or our discussions with our landlords about the credit score, because it really should focus on the content. So when I talk about the content, I mean things like, all right, do they have two collections, or maybe they've got an overdue credit card, or they've got delinquent accounts for their mortgage, or whatever those things are that you're coming up with, or maybe their references were bad. Those kinds of things are things that you can use, but you can't use the credit score, and we'll talk about that in a minute. We'll come back to that topic, but in a greater extent, because the law is silent on what happens in the event of those disputes, we're going to assume that it doesn't stop you from trying to obtain another tenant until we're told otherwise. That's the assumption. So we should be allowed to, unless somebody tells us that we can't. So so next topic. So the law also stipulates that we cannot charge more than a $50 rental fee application, and until January 1st of 2024. And now what we're using is, after January 1st of 2024, is we're using a new formula that's adjusted annually by the housing provider or is excuse me, his or her agent, commensurate with an increase in the consumer price index for all urban consumers. So there is the city is promising to come up with a calculator that you can plug in right now. I haven't seen it yet, but they're promising that it's coming. So for the time being, my suggestion is don't charge any more than $50 for your credit application fees.
How much does Rent Spree charge?
$49, I think it's $49.95, I think.
Okay.
So technically, and according to the screens that we just saw, if the rent, I kind of skipped over that part, but let's say that the application service that you're going to be providing charges only $40 and you charge them $50. One of the previous screens that we looked at told us that we have to refund that $10 back to the tenant once the screening is done.
Okay.
Mm-hmm. So that can't be pocketed by us or by the landlord. So, all right. So beginning on January 1st, there's a new formula based on the consumer price index, and that formula should be coming up soon on the website in a calculator that you can use for that purpose. But right now I haven't seen it yet. All right. The next topic: if a housing provider fails to conduct a screening of a prospective applicant for any reason, the housing provider shall refund any application fee provided by the prospective tenant within a reasonable time not to exceed 14 days. So you collect the $50 from the tenant, but for whatever reason, you don't process the rental application. And if you're using Rent Spree, it's kind of automatic, so that really wouldn't matter. But if you're going to receive a Rent Spree application, my suggestion is the best practice is you vet each of your applicants one at a time in order of receipt of that application. You vet the first one out, you look at the terms of their credit file, you determine if that credit report satisfies the needs of the landlord. If it does satisfy them, then you approve them. If it doesn't satisfy them, then you reject them and you move on to the next one. But I wouldn't run simultaneous applications because of these new laws. In DC, I would not recommend running simultaneous applications on people. So that means you're going to have to be very careful about who you're delivering the rent spree link to, should that be necessary, because you don't want to have, because as soon as you deliver the link, people are usually prone to going ahead and starting their application and processing it. Rent spree is not going to prioritize one or the other. They're just simply going to run them all together. So if you end up running it and you don't give them the benefit and then of the rejection of the first one, then you could find yourself potentially with two applicants who have now qualified, and now you've got to reject one of them, but you don't know how to reject them because they're both qualified, but you've got to reject one of them. And now you're going to have to say, well, it's because this other one was first, or some other subjective means of determining who's better. And so the way to avoid that is to run the first applicant, determine if they're qualified. If they are qualified, then great, proceed to a lease. If they're not qualified, reject them and move on to the second one. That's my recommended strategy, because you're going to get yourself into some really ugly scenarios if you don't do it that way. Any questions on that? It's not great. And I'm going to admit to you that these new laws are going to cause a lot of cumbersome transactions in the district as a result of these new laws. Totally get that. All right.
It seems it's a little counterproductive because I know people, I don't do many DC rentals. Actually, I don't think I've ever done a DC rental for a landlord, which now that I'm listening to this, I don't think I want to. But in Virginia, I mean, people beg to have an application link.
Yeah.
You know, even if you tell them you have an open house and you say, you know, somebody applied yesterday, we're going through it, and you have 15 people come to the open house and all 15 or 10 of the 15 want a link.
Yeah.
It almost seems like those laws opening you up to being discriminatory, or not to being discriminatory, but to potentially running into an issue.
Yeah.
If someone's like, hey, I came and whatever, I have 4 kids and they just didn't want to give it to me because of that. But
yeah,
it's not.
Exactly. And you're exactly correct. And the law doesn't even address they didn't think through this stuff. You know, my job is to present it and to make sure that we understand how we should handle it. But I think you're absolutely right. You raise an absolutely correct scenario that I don't think that there's an answer for yet. So yeah, I would totally agree with you. Shafiq, you're awfully quiet in this.
Dan, and Irene, I guess I think that wouldn't Rent Spree or whichever company we're using, I've used Listing to Leasing in the past, there's an order in which they come in. So you can still go by the order in which they come in, right?
Yes, you could, but you could also have yes, there is an order. There is
I mean, even if it's a couple minutes, there's going to be a difference.
Yeah, but I would go ahead and make sure that you review the first. I guess the point is, make sure that you review the first one, come up with a decision on it before you start looking at the second one.
Yeah, you can't sit there with 6 applications in front of you and.
Exactly. And then what's going to happen when renter number 2, so renter number 1's application comes in, you go ahead and approve it, but almost like a minute later, renter number 2 submitted their application and they've already paid for it. And now you've got the service has been provided to you by Rent Spree or whichever service you're using. and and now they did, and you tell number two that sorry, number one got it and they were here first. Number two is then going to turn around to you and say, well, refund to me my application because you didn't tell me. So you see how that's going to get sticky and ugly?
Yeah.
Yeah. So I don't have an answer for you on how to handle that, because the law is silent on it. So
You just don't, you take in one application and then you don't take any others until you've processed it.
exactly, that's
You
what
don't
I'm,
even look
that-
at the other ones. The first one that comes in is the winner, if they check out, you know.
but in the scenario that we just talked about, what Mel just said, if they're 2 minutes apart or 1 minute apart,
Mhm.
but they've both paid the fee, and one of them is going to want their fee back because they didn't even get a chance to be considered. You know, as
I haven't used Rent Spree, but can you turn it off and turn it back on and turn it off and turn it back on?
yes, yes, you can.
Yeah, I think you can do that in listing to leasing too, now that I think about it.
Yeah. So that's
Pat,
probably,
here's
that's
the-
probably the thing to do, but that means you're going to have to stay on top of
Yeah,
that.
yeah.
Yeah. So
Pat,
it's, yes.
this is Shafiq. So my problem with this is that we have landlords. I'm a landlord. I want the best qualified tenant.
Right, not the first one.
Right. And that's where the design of this law, part of the, I'm not saying that this was, I'm not advocating for this law. I'm saying that it is in place and that's where it was. That's what the law, this is what the law says. And I do agree that you are looking for the best qualified tenant. And in order to do that, you would collect a number of them and compare them with one with another. But when you do that, you're opening yourself up to being subjected to a dispute or a complaint, which on the previous screens that we were just talking about. So just be aware of that. There is a risk in doing that. That I know that's not a good, I know that's not the answer you want to hear, but that's what it is. All right. Next topic, a housing provider. Whoops. Hi, Shafiq, did we miss you? All right, not sure what's going on. So a housing provider shall not base an adverse action solely on a prospective tenant's credit score or lack thereof. Although information within a credit or consumer report directly relevant to fitness as a tenant can be relied upon by a housing provider. So as a company policy, we are stating that we should not be using the credit score itself in any way, shape, or form as a deciding factor in approving or disapproving the applicant. Instead, use the content of the credit report itself to make the decisions.
How does this help anybody? I mean, the credit scores were supposed to have already gone through all that information,
Yeah.
and that's why you have this score. So now they want us to be like credit people and try to figure out.
And
What is that?
you're exactly right. And there is a certain amount of this that does conflict with federal law.
Yeah, it feels funny. I don't want to have to dig through all their,
Yeah.
I don't want to know all that stuff about them. You know what I mean?
That's
I
why.
want to know what I need to know, but not all, you know what I mean?
Yeah. Yeah. So
Yeah,
what
that's what
I
is
think,
enacted.
I'm sorry. Yeah, I think what we're going to have to do is to look and consider what is the, we're going to have to look at the content of that credit report and decide whether or not it's acceptable or not. And decide what, if it meets the criteria that you outlined to the tenant before. Like we were just talking about a few minutes ago, you've outlined already to them what's going to be the deciding factor in your ability to process this. So you're going to say, we will look for this stuff to approve you, and we will look for this stuff to disapprove you. And hopefully you'll fit into one of those categories, and that's where the approval will come in. So you cannot use a credit score to as a basis for the decision making.
So I have a question on that one too. So we have, when you're saying that's a company policy, do you mean just for DC or for everywhere?
Yeah. Just for DC. This is just
Okay.
DC. Yeah, this is just DC.
Because I'm like, listening to leasing, you literally, and actually regardless, so specifically to DC.
Yeah. Oh, this entire class is only DC.
Yeah. No,
Yeah.
that makes sense, but I just want to make sure on the policy. But
Oh, yeah.
in this case, so if there's a DC landlord, and so I use listing to leasing, and one of the things I like about it is that it asks, or it requires the permission of the applicant to give that report not only to me but to the landlord, so that they are directly authorizing that. But it comes with, I don't think you can say, take out the credit score. So how would you?
Yeah,
do it?
and Rent Spree will also deliver you a score as well. It's going to be, the law is silent on that. So we're going to have to imagine that the score is not there. I don't know how we, in
So
practice.
these people are going to think we're making personal decisions on them, and the way they live, it feels so uncomfortable to.
Yeah,
Seriously.
yeah. I do like the credit score approach myself. I think it's less prone to being discriminatory, but according to this law, this is what the city council came up with, and the mayor signed off on it. So
Okay, so the issue isn't so much that the landlords or we have a credit score. It's just that if we're rejecting them, we can't say, oh, you had a 620.
yeah,
We have to say, oh, you had your last 3 credit card payments were late.
exactly.
Okay.
Jen,
Exactly.
can we say, let's say they have a fairly low credit score, but they don't have any late payments, but their amount of credit that's outstanding is incredibly high.
Yes, that would be a legitimate. That would be like a debt to income ratio kind of argument, and that would be a legitimate reason. So what I would do is, in your earlier statement, when we were just talking about this a few minutes ago, I would say your debt to income ratios cannot be greater than this. So I would use that. I would make a statement up front to say, we are looking for people with debt to income ratios no greater than X, whatever X is.
Can you guys make some kind of set forms that say all of this, so we're saying the same thing and we're not screwing it up when we talk to them? Because there's so much.
I have one. I have created one, and I can share it with you.
Yeah, can you please?
Yeah, I have created one for myself. It's not sanctioned by any formal, it's not sanctioned by a GCAR. It's not sanctioned by the DC Real Estate Commission. It's not sanctioned by any attorneys or by the company for that matter. But I have created one because I see that the law has a gap in what the forms are. And I sit on the GCAR forms committee right now, and we're working towards getting some forms together, but they're not going to be delivered anytime soon. So for now, I'm using this form whenever I have to use it, and I'll be able to send you that.
So,
thank you.
Dan, in your case, are you emailing or giving them this form in advance of asking for an application?
Exactly.
Or are you giving them the application and saying, here is the criteria at the same time?
When I receive the email link, if I receive a KV Core request to see 123 Main Street, the first thing I'm doing to them is boom, firing this thing off. And I've now satisfied all of my obligations.
But if you're getting a cold call from a client, I want to see 123 Main Street, from some other person's perspective listing, you don't even know what that criteria is.
Exactly. So this is for tenant screening. So I don't believe that this applies for you qualifying renters in general, if you're going to be in tenant agency, and you're going to be showing, you know, a Compass list rental listing, I think that it is not my understanding that this law applies to that situation. This situation only applies to you when you're a listing agent or a landlord.
So as a listing agent, this is the list we would have to provide. Compass was asking us that Mary would like to apply for this unit. We would be required to give Compass or anybody this list of what the criteria is in advance of accepting the application.
Yes, correct. That
is not done in DC at the moment by anybody.
Yeah, exactly. I know that,
and
and I
I'm
know,
aware of, at least.
and I know that that's absolutely true. I know you are absolutely correct, because I've been going through some rental transactions lately, and I know nobody's doing it. However, that's what the law says.
So going back to, I'm sorry, I was in a room, I couldn't speak. Going back to the landlord tenant advocacy group.
Yes.
Have you ever reached out to them? I have on several occasions, and they are very difficult to get a hold of.
Yep.
And they are very difficult to get an answer from.
Yep.
So if someone was to make a complaint, I don't think it would go to them. It would probably go to somebody else, because
So
I don't know if they're required, they can take the complaint.
So it goes to the Office of Human Rights.
Office of Human Rights, which typically takes a month to do the intake and 3 to 4 months to do investigation.
Right.
And then
by then you've already rented it to somebody else.
Yeah.
So I'm wondering what would happen. Would they say you have to unrent it to this person?
I don't,
Yeah.
I don't know. I don't have an answer for you, because the law is silent on that.
What is the consequence of doing
The law, again, the law is silent on that. There is no consequences that have been built into this law.
So if you don't do any of this, what is the consequence?
Oh, if you don't do any of this stuff, if you don't do this disclosure, well, the law doesn't even state that.
So why would we worry ourselves if there's no consequence to the law?
Well, I don't know that I would want to be the test case to find out what the consequence is. And as this, as the supervising broker for the company, I wouldn't want to be in the position to have to defend any of you in front of the real estate commission if that ever came up, or in front of any other DC government entity. I mean, I would definitely fight hard to defend all of you, but that, because it's uncharted territory, we don't know where we would go from there, and the law is very.
Do you know if this has come up at grievance or at?
To my knowledge, I have no knowledge of anything coming up in grievance about this.
Or at not at the advocate, but at the what was the other? No, at the housing authority.
Yeah, I have not.
Discrimination authority.
I have not heard anything one way or another. I don't think anybody's actively enforcing this. All I'm doing today is teaching you what the law is, so that we don't find ourselves getting into trouble blindly not knowing what the law is. Okay. Because the law is silent on a lot of these questions, there's really not a lot to go on.
Okay, maybe I'm getting ahead of you. Are you gonna go into the new forms as well?
Not on the new form. We did the new forms class a couple of months ago. And there's going to be a new release of the new forms coming next month also. So once
No,
that's,
No, but as part of this law, there's new forms.
oh,
that
no,
are
there's no,
required.
as part of the law, there are no new forms part of the law, as part of the law. Right now, there's no new forms for this law. The GCAR Forms Committee is working on that right now. And I sit on that committee.
So
we
there's new
are working-
Form 5A, Form 5, Form 4, Form 3 as part of the rental lease.
Say, I'm not following you. What did you say?
As part of the rental lease in DC.
Yeah.
There is new, like if you look at zip forms and the criteria of the checklist of what you need.
Yeah.
They've added Form 3, which is in there, and then Form 5 and Form 4, which are not there. So you have to go to the DC website to get those two forms.
Right. I don't have that right in front of me. Don't have that as part of this conversation,
So,
but we can dive into that at a later date.
okay.
Yeah.
All right. Sorry to take you off track.
Yep. No, that's fine. Excuse me. All right. The next topic. We've already talked about this. The credit score. All right. Okay, if you take an adverse action, so what's an adverse action in a tenant screening process? Who can tell me what that is?
Saying you're not qualified.
Not accepting, yeah.
Correct, right. So if you're going to take an adverse action or denial is issued, the housing provider must provide a written notice of the denial within response date in advance. So when you've stated in advance that the decision will be made by, May 15th or whatever it is, you need to give them that answer by May 15th. So you got to give them that answer, and you've got to provide this in writing to them. You have to give them the specific grounds for the adverse action, the written notice on the specific grounds for the denial. You have to give them a copy free of charge of any information obtained from a third party that formed a basis of the adverse action. So that means you've got to give them a copy of the credit report.
But if we don't get that, I mean, a lot of time I don't even get that from Rent Spree. And does Rent Spree have to give it to them? I don't.
Yeah,
What do you get from Rent Spree?
Yeah, Rent Spree gives you the credit report. They give you all the information in the credit report.
Okay.
Yeah. And you would just give them a copy of whatever that is. You've got to give them a free copy
Why
of the
doesn't Rent Spree just send it to them when they do the report?
I think that is an option in Rent Spree.
Yeah, because why
I do
not?
believe it. Yeah. So keep in mind, Rent Spree is a third-party service provider, and they provide services all over the country. So they're not tailoring this specifically to DC law. They're just trying to
They
satisfy.
should if they're going to work in DC, just like
Well,
we have to when we're working here.
Yeah, I mean, you're preaching to the choir. I can't control them. So, but you're right. I think that you're right that that's something that they should probably adapt their systems to provide. Absolutely. So you got to provide a free copy of the credit report and any information obtained by any third party. A statement informing the prospective tenant that his or her right to dispute the accuracy and permissibility of the housing provider's use of the information upon which the housing provider relied in making his or her adverse action determination. So if you're going to make a denial, you have to inform them of their right to dispute the accuracy of whatever it is that, so if you're using the credit report, they can dispute the accuracy of that credit report. What you do with that dispute is an open-ended question. The law doesn't give us any guidance on what to do with that. So then we have to also provide them with a statement of to file a complaint with the Office of Human Rights if he or she believes that a housing provider violated this section. So we all know that source of income is a protected class. So if we are putting a total income necessary to qualify for the rent as one of the criteria, and we're going to say that you must have total income of, whatever X is, then you must include in that calculation for X anything that's provided for within the voucher system. And whatever their income is, their entire income picture must include the voucher aspect if there is a voucher applied. You may not discriminate against anybody for having vouchers, and that now you can discriminate against them for the content of their credit report, but you cannot discriminate against them for the fact that they have a voucher.
Can you discriminate against them for not wanting a guarantor?
Yeah, sure.
You can say, based on your credit history and your amount of debt that you have, we
Yeah.
won't accept you. They say, well, I can get a guarantor. You could say, we don't accept guarantors.
Oh, well,
So I'm thinking of college students.
Yeah, no,
Yeah,
I know that's what you're thinking of, but can you say no? Because
I'm gonna have to get back to you on that.
they're going to have somebody co-sign, yeah,
Yeah,
because that's a source of funds, I think.
yeah, I think you're right. I think Julie's right. I think that is a source of funds. It is a valid source of funds, and if you discriminated against them, that would probably fall under the source of funds discrimination.
Because no
Okay.
kid is out there can qualify when they're in, well, not.
As-
But
they're in
what about a
college, so-
source of funds outside of the country?
Yeah, we're gonna have to, I'll have to figure that out. I don't have an answer for you on that. I don't believe that out of the country matters.
Because you can't run a credit on a foreign national.
Exactly. That's where I was going with that. So I think what would have to happen is, I think, like if you're able to find some kind of a credit reporting system that is deemed reliable, I think that's a possibility that you could do that. But I mean, even Great Britain and their credit reporting system, or even Canada. What does Canada have, Shafiq?
We have social security numbers, but I don't know of any service that would run a credit report outside of the US.
Yeah, exactly. Yeah, so I think I don't know the answer to that. I'd have to dig into and get some answers back to you. I don't know. I don't want to say something that I don't really know. Okay. So that's basically the end of that discussion for chapter 42, chapter 35 of title 42.
Before you move on, can you deny someone based on an eviction, prior eviction,
We're gonna talk about that next.
and a criminal record?
Yeah, we're gonna talk about that right now.
Okay.
DC sealing of eviction court records. This is a new law that was enacted also at the same time. All right. Who's an aggrieved person in an eviction proceeding? So if there's an eviction proceeding, who is the aggrieved entity? Who can tell me that?
By DC, it would become the tenant.
Anybody else have any thoughts on that?
No, it could be the landlord too, if they want to get somebody out and doesn't want to leave.
Yeah,
Could be both, right?
Julie's right. In an eviction proceeding, the aggrieved person is the landlord who's looking to collect the possession of their property for whatever reason. Maybe the tenant's not paying, maybe they're doing illegal activities. So the aggrieved person in an eviction proceeding is the landlord. Okay. So eviction proceeding, sealing authority and fairness in renting amendment act of 2022. Now pay attention to this because this is pretty significant. A person aggrieved shall not file a complaint seeking restitution or possession for non-payment of rent in the amount of less than $600. So that's easy. So you can't evict somebody for an amount that's due for less than $600. Okay, that's easy, simple. I don't know of anybody who would want to do that anyways. The lessor, the landlord, cannot evict if they do not have a current rental housing license, other legal terms and procedures should apply by should be managed by legal counsel, not by real estate licensees. Without a current rental license and requires written notice of a lessee of their intent to evict. So you've got to provide written notice of their intent to evict them. You've got to require photographic evidence that you've posted that notice to them at the property, on the property. You have to provide that notice to them, a picture of the eviction summons in the tenant's own language. So if they are speaking a foreign language, it needs to be printed in their own language. It can't be printed in English if they're a foreign national and don't speak, and if they're a foreign national.
Excuse me.
It prohibits the eviction of a lessor that does not provide 30 days notice eviction. So with that written notice must be given more than 30 days before the filing can begin on the eviction proceeding.
Just to add to that, Dan, even if it says in the lease, you're waiving this right, this supersedes that right in your lease.
That is correct. That is correct.
And I will also add that photographic evidence must show the date and time to the minute of when it was posted. And then you require an affidavit saying that it was posted at that time.
So
Right.
they just use the information on your camera phone, your phone,
It has to show the exact time.
right? But
It
I
was
mean, how do
posted.
they'll take what a camera, they'll take your phone as.
No.
Time?
They need a printout of that picture with the actual date.
Okay,
and
so
time.
but the date, when you take the picture and you print it out, there's a date from your phone. That date will suffice, you're saying.
Correct. Yes,
Okay.
but so I went through an eviction recently and we did not have the date. And it was thrown out.
I see,
On
I have
the
pictures of us
technicality.
standing there with taking pictures of today's newspaper to prove the day, but I guess I'm off.
No, so and
Fine, too.
you can't. It's in best practices that it be process server that's actually doing it and not the landlord and not you.
Yeah, we don't.
Oh, that makes a
we
lot
as
more
a-
sense. Sorry, okay.
Yeah, we as agents, that's why in one of the previous screens here, we covered so this last sentence, other legal terms and procedures that should be managed by a legal counsel, not real estate licensees. So
Okay.
we should not, these are
God.
things that need to happen, and it needs to be under the it needs to be done by the attorneys. We as agents are not the participants to do that. Now, if you
Yeah,
are
we're not supposed to be the tenant police, right? I mean,
Correct.
we're just.
that is correct.
Okay.
Yeah,
We're just
unless, I
supposed
mean,
to
if
put
you are
people in-
if you are a licensed property manager, then that may or may not be part of what your property management your property management agreement with the landlord is. But
Right.
the better practice is to use a process server and have an attorney guide this whole thing. Photographic evidence. Okay, let me see here. Prohibits eviction if not less than 30 days. Discussion. Okay, so there was a point that I forgot that I got sidetracked on, and I've forgotten what it was. Oh well, we'll continue on. We've only got,
Going back to the other one, I think it's required. Even if the person speaks English as their primary language, is English and Spanish. That notice has to be done in both languages.
yeah. Well, this law is only talking about the language of the person. It doesn't say both, but there may be other laws in DC that do require it in both.
I think it's both languages plus the language of the person,
Right.
if it's other than those two languages.
Okay. Good to know. Good to know. Okay. Now, so here's some important things for us to know. If the eviction proceeding does not result in a judgment for possession in favor of the housing provider. So who's the housing provider?
Landlord.
Landlord, okay. If the judge, if the proceeding, the eviction proceeding does not grant the eviction to the landlord 30 days after the final resolution of the eviction proceedings. So the Superior Court of the District of Columbia shall seal all court records relating to an eviction proceeding. If the eviction proceeding does not, so if the judge says no, we're denying your eviction, then the record is sealed after 30 days, and in theory, the court is supposed to force Rent Spree or any other service provider from, they're supposed to be prohibiting them from entering that into the credit file of that individual. Now, whether that actually happens or not is another issue, but I would caution you that if it does appear in the credit report that an eviction proceeding, in the background check, that an eviction proceeding was enacted, but did not result in an eviction proceeding, and it is beyond that 30 days from that proceeding, you do not want to base your decision on that eviction proceeding.
Dan, I've never seen a credit report say proceeding. I've only seen it say eviction
Right.
Resolved, like
Yeah.
Restitution has been provided.
Exactly.
So I've never seen one in process.
Yeah, and I have not either, but I guess it's a theoretical possibility.
Well, I
So-
guess someone could go and look at the records of who's being in the process of being evicted.
The point is, if somebody has been process served for eviction and it was not granted, we can't use that as a basis for them to be evicted. All right, next topic. What happens when the result is successful? Okay, if the eviction proceeding results in a judgment for possession, meaning the tenant was evicted in favor of the housing provider 3 years after the final resolution. So if the eviction proceeding is less than 3 years, you can use it as a basis to deny a rental application. But you cannot do so if it is after 3 years. So if it was more than 3 years ago, you can't use it as a basis to deny them. And it's probably going to be sealed anyways. But if it's not sealed and it's still showing up in their credit reports, you can't use it as a reason to deny them. The Superior Court shall seal court records relating to an eviction proceeding at any time upon a motion by the tenant if the tenant puts to the court a request to seal the records, the tenant demonstrates a preponderance of evidence that, and there's a bunch of if, ands, and buts that I'm not going to get into. Just know that there is a process that the tenant can apply to the court for that can seal the records of their proceedings and make them not enforceable by entities for the eviction purpose or for using that against them in their credit files. So this should be waking all of us up to our activities in renting in DC to make sure that we're really being aware that there really is some serious consequence. There's some serious legal reasons why we really need to be very, very careful, and we don't quite know what the consequences are. Real quickly, if you're going to have a rental housing business like a short-term rental or a long-term rental, you've got to have a basic business license. If you don't have the basic business license, that's also a reason for the court to reject your eviction proceeding. If you don't have the basic business license, if you don't have your RAD registration number or RAD exemption number or the rental license itself, you got to have those three things. And if you don't have one of those three things, then the courts will automatically reject your application for an eviction proceeding. Is that giving anybody some aha moments?
And often, if it slips through and it comes to the judge at that moment will tell you after
Exactly.
6 or 8 or a year later.
Yeah.
That it failed.
Yeah, exactly. So that should give us all some aha moments. I'm not going to go into great detail on this, but it covers condos, co-ops, single apartments, 1 and 2 family housing, and apartments of housing of 3 or more. It also includes ADU possessions. So in order to get your rental housing license, this is from the website on the city's website, and I'm going to give you this PowerPoint so you can review this information. We're running out of some time here, so I did want to just kind of cover a few of these things. This is taken from the website for getting your rental housing license, your basic business license, the RAD registration. Does anybody not know what the RAD number is and the RAD exemption number?
I don't know.
So that's the rent control, okay? And if you're going to be renting a property out in DC, you must, by law, have the RAD number, meaning you are rent controlled, or you must have a RAD exemption number, one or the other. If you're going to rent it, it must have one or the other. A RAD exemption is usually issued to a single owner who owns one property in DC and is using it as a rental property in DC. That's one of the exemptions is for that purpose. If you own multiple properties, like Shafiq, how many do you own?
I have 5 residential and 1 commercial.
So because Shafiq owns 5 residential properties that he's renting out, he does not qualify for an exemption, and he must register with RAD as with rent control.
But
So
even if I had 3, I would still have to register with them and file the and get an exemption number.
exactly. So you must.
So I think some people believe that if they just have 1 unit, they don't need to file. They need to file.
Yeah, you have to file. You have to file and get that approval. So Julie, the point here is you must have the RAD exemption number, you must have the basic business license number, and you must have the rental license. Those are the three.
Are those 3 things requirements for us as an office to take on a listing for lease in DC?
Yes.
I just think maybe I heard you'd need the RAD exemption or the number. You need the rental license and the business license, did you say?
Yes.
Oh, brother.
Basic because DC considers a landlord to be a business.
Sure.
And of course they want your tax money. So
But if you're already paying with rental licensing for your business, you have to, that seems like double dipping.
No, Dan, you need the business license and you need the RAD or the exemption. Those are the only 2 things you need.
Well,
You don't need a rental license, a separate thing. Oh, good. Okay.
But you do need to get the approval from the rent control. They need to come in and inspect the property. And
Right, but they're not going to issue that business license until they've done that.
exactly.
So I guess the third thing could be the certificate of occupancy.
That's yeah. And a certificate of occupancy is a different issue. Not all properties will be required to have a new certificate of occupancy.
Yeah.
So just be aware that you're going to have to verify that you have clean hands with the city, meaning you don't have any outstanding debts payable to the city. So this is what the registration or claim of the RAD exemption or RAD. This is an actual document that I have used in one of my rentals, and I've crossed out the numbers referencing my actual landlord here. But this is what it looks like. So you should be receiving this, and this is what it looks like. So short-term rentals, you have to apply for a similar kind of application if you're going to be using Airbnb, a property for Airbnb. So we've got that as a topic here. I'm not going to go through that right now, but we'll just go ahead and open it up. If anybody has any open questions for me or for Shafiq, that should give you a good place to start out from.
It's tough being a landlord in DC.
That's the
What
whole,
if you're
that's
not
the
a
message. That's
What
the
if you're
message.
not a licensed realtor? How much of this is required?
Everything,
All of it. Yeah.
all of it. It doesn't have to do anything with our licensing.
And
It
we,
has to be with breathing in DC.
right. And we can't be parties to creating a lease that is not satisfying the law. right? If we created a lease that didn't satisfy the law, we would be parties to creating an illegal document, and we would have liability there. So because of that that vicarious liability, we have to be compliant. We have to ensure that our clients are complying. Any other questions, Irene or Jasmine? Well, you got anything, Shafiq? Anything else to add?
Just to add, I mean, it sounds like it's a lot in DC, but if you actually understand the laws and you understand the processes, you can be a great advocate for your owners to do the right thing and make money.
And that's exactly right. You develop the systems in place to make sure that you're compliant, and it does work. You go through more hoops than you certainly would in Virginia, but it does work, and I've done it successfully, and I know Shafiq has done it successfully. So
The rents are high in DC and still continue to be high.
to mod new laws with possible unintended consequences, but most, let me see what she's saying here.
Sorry, nothing important. I just was having trouble actually getting to my mute button.
Oh, okay.
And at that point, you guys were talking, and I was like, "Oh, let me just text that out." So
Yeah,
DC
So-
passes law that don't make any sense
yeah.
most
So
of the time.
yeah, and so that's why, Julie, I was very concerned when I heard that you were coming up with a new one, and I wanted to make sure that you had some of this information.
Yeah, no, I need to know this because I haven't done a rental in a really long time in DC. I've only done sales, and with Alex buying this, actually, I'm not doing it. Looks like his wife is going to be doing it, and he's not licensed in DC, and she's not even a real estate agent.
Well,
I don't know how, yeah.
she needs to be careful, because if she's acting as a licensee,
No,
Um,
she's not. She's just acting as an owner of a property that wants to rent it out.
okay, all right.
Yeah. No, she's not acting like an agent.
But
Okay.
she still is required to follow all those rules.
Exactly.
She's not exempt from any of those rules that Dan has outlined as cumbersome and difficult to even understand as they are.
Yep.
I really think she's gonna go through the application process and find the tenants, and then they're gonna throw it all at me after that to do the lease, so.
Now, there is a service that will go ahead and get this. There is a couple of service providers who will go out and get all of this stuff set up for you to make your rental listing legal, so that you don't have to do it yourself as a listing agent, and your landlord doesn't have to do it. And one of them is called BBL Processors. Have you ever used them, Shafiq?
No, I'm not used to them. I know who they are.
Processors.com, bblprocessors.com, and for a fee, he will provide you with all of everything that you need to make your listing legally compliant, in order to get your rental legally compliant with the city. So bblprocessors.com.
Okay.
Jean Poitevin is his name, and he's also a broker, a licensed broker in DC, and I think he sits on the real estate commission right now too. I think
He's transferring his business to someone else, though.
oh, is he?
He's moving to Florida.
Oh, I didn't know that. Oh, okay.
Yeah.
Right. Well,
I always call him for advice.
yeah, he's a good
My
guy.
resource of anything I don't know, call Jean,
Yeah.
because he knows.
Hopefully hopefully the business will stay alive and be run just as well as he has it.
There's
So-
another company as well that does a similar thing. I can't remember the name of that.
Okay. Good deal. All right. Anybody has any questions? Hit me up, chat me, text me, phone me.
Thank you.
All
Thank
right.
you.
My
Thank you,
pleasure.
Dan.
thank you.
Anytime.
Appreciate it.
You're gonna share the slides, right?
Yes. Yeah, I'll send them to you. Yep.
Thank you.
Thank you.
Thank you.
So much.
Yep,
Okay.
Take care. Bye.
Thank
All
you.
right. Bye-bye, everybody.